Casey, for coming and indulging our questions. 1 month ago, Chairman Conyers, Representative Pascrell, and I sent you a letter addressing our concerns about the growing number of deferred and non-prosecution agreements handed out by federal prosecutors. To date, we have yet to receive a response from your office, but we discussed this personally on the phone yesterday. But I just want to bring to your attention that that letter highlighted a study that was conducted by Lawrence Finder and Ryan McConnell, which found that the number of deferred and non-prosecution agreements between the Department of Justice and corporations had grown exponentially last year to 35 from just 5 in the year 2003. Having said that, that study in many ways is incomplete because in fact, there is no requirement to report these agreements, and therefore we're not even sure exactly how many agreements between corporations and federal prosecutors actually exist. I'm curious in knowing when you will disclose to this committee all of the information relating to these agreements that was requested in our letter of January 10th.
You're right, we discussed this yesterday, and I'm going to get back as promptly as I can with respect to your letter. I do want to stress, as we discussed yesterday, that the increasing phenomenon of monitors is something that we noticed well before there came to be publicity about it and have been looking into. We've asked the Attorney General's Advisory Committee, which is a group of United States attorneys from around the country who can gather information from United States attorneys about both the prevalence of the phenomenon and whether there is a way of coming up with best practices or guidelines.
But the question I'm asking you is, when can we expect to receive the information that we've requested in the letter?
I can't give you a deadline. That's one of the things we want to gather up to figure out not only the numbers, but what to do.
Okay.
It's an outgrowth of increased prosecution of corporations.
Let me ask you this. Do you support the full disclosure by the Department of Justice of all deferred and non-prosecution agreements prospectively in the future moving forward?
With respect, I would like to hear from the Attorney General's Advisory Committee as to not only the prevalence of the phenomenon, but whether confidentiality agreements serve or disserve the larger interest in seeing to it that wrongdoing is rooted out, that people who have to be prosecuted, individuals that have to be prosecuted are, and that unnecessary damage isn't done.
So
within
at this
those
point,
minutes, I will try to get the information.
Okay. Now, attention to the issue of prosecution agreements came about in part because of the actions of U.S. Attorney Christopher Christie. In the process of deferring a prosecution, Mr. Christie selected his past superior, former Attorney General John Ashcroft, to serve as a federal monitor and collect fees reported to be in excess of $52 million. I know that during your testimony to the Senate Judiciary Committee, you admitted deficiencies in the way that federal monitors are selected and made the suggestion that in the future, federal prosecutors may have to submit reports to the department on the selection of those monitors. Do you believe that a lack of guidelines on how independent corporate monitors are selected has fostered the appearance of cronyism, where U.S. attorneys can appoint their friends and former superiors to those lucrative positions?
I think it's helpful to have the experience of other U.S. attorneys before a U.S. attorney embarks on a course of conduct, be it the selection of a monitor or anything else. And without getting into labels like cronyism and so on, I think it's useful to know what the best way is to go about it, whether it involves the company in the process of selecting from a group or what.
Let me ask you, do you think that the contract that was awarded to Mr. Ashcroft was excessive?
I don't know the details of the contract that Mr. Ashcroft has, and I would point out that the money that we're talking about is not public money. This is money that comes from the corporation. I know no other details.
One of the things that I'm very deeply concerned about with respect to this particular issue is the lack of any judicial oversight in regard to deferred prosecution agreements. And I'm going to give you just an example. For example, if an individual is charged with a crime and agrees to a plea bargain with the prosecution, then that plea must go before a judge who has the power to deny and in cases alter that agreement based on judicial discretion. However, with regard to deferred prosecution agreements that are struck between federal prosecutors and corporations, neither party ever sees the inside of a courtroom, let alone has to put these agreements before a judge. So I'm wondering if you are concerned that this has created two completely different systems of justice, one for individuals that is accountable to the judiciary, and another for corporations that is based entirely on the discretion of federal prosecutors.
Prosecutors proceed under guidelines that are very strictly set by the department, that are very strictly reviewed by the department.
But there's no judicial review of those deferred prosecutions. Or am I mistaken in that?
I think you're not mistaken about the question of whether all such agreements are reviewed.
Do you think it's generally good policy that they would not be reviewed by a judge?
In order for an agreement to be ordered, it would certainly have to be reviewed by a judge. I think that the decision whether to charge or not charge has always been an executive decision.
And
prosecutors reach those decisions in all settings,
but
regardless
yet
of whether they involve
Chairman,
non-prosecution agreements.
My regular order time is.
I see that my time has expired. I will submit follow-up questions in writing, and I thank the chairman for his indulgence.
Mr. Chairman.